Hey guys, long time no see. So hopefully I'll be curable. It's coming what sounds like a typhoon outside, but it's just like really high wind. So just an update on everything. I filed everything in the nick of time on the 30th. That was my deadline. The objection to the Demurrer and also the objection to their request for judicial notice. And I'll go through the main points of all of that with you. So it was kind of an arduous process, especially since I am working full-time in med mal now. So, and also the subject matter with which I work, on a regular basis now is kind of heavy too. Like there's a case right now involving the death of a child, for example. So, going through all of those records and looking at all that kind of stuff and all that entails, getting like dozens of people ready for a deposition and stuff around making sure I put everything in this and then get it filed was not that easy. So I did get it done, but it wasn't like it would have been had I had a lighter workload. I would have tried to do it a little bit earlier and then make content last weekend about it, but caused a bit of a delay, but thankfully it's done. So yeah, let's get into it.
3, 2, 1, go!
Okay, guys, so you see here, my info's redacted, so it's okay to show that now. And our hearing date is pushed out to January 6th. So that's great. Gives a little time to, not have to focus on this and then be really ready when we get going on it. And also, in case anybody doesn't understand what a demurrer is, so what YouTube and Google usually file when they're sued is a demurrer. And what that is when somebody wants to claim that your facts are actually they're not going to bother disputing those, that they're actually valid or that they may be valid. But and they do this when they know they are valid and don't want to get into that because let's face it, they can't. If they could, they would have, called this a frivolous lawsuit or tried to claim, that what you're stating is afactual and get a summary judgment, but they can't do that. They wouldn't win on that. So what they do is they try to say several things. One would be that you don't have standing as a person to bring the complaint. Or a lot of times people will file something in the wrong jurisdiction and they'll claim, well, you can't file that here. That's a federal issue. So we've made this civil, and it is. So they're not doing that, but they're saying that I haven't stated facts sufficient enough to constitute a cause of action. So that's also in line with their third argument, which is that they always try to say you haven't met the elements required for something you do have standing on, but they're trying to say it's ambiguous or that they're, not quite sure that you've stated something intelligible enough to put together all those elements as you need them to make that cause of action. And then the other would be Section 230. So platforms, what that is it's a part of the Communications and Decency Act, which gives platforms immunity from being liable for what third-party content creators do on their platforms. They have that immunity for the most part, but there are exceptions. And one of the major exceptions is child sex abuse or children in danger of terroristic crime being committed against them. And, I've proven that up in the other pleading with case law, but nonetheless, these are their arguments here. So we're going to look at what I said in response to this. Their first argument against me is that I didn't state facts sufficient enough to constitute a cause of action under the Cali Code of Civil Procedure 43010E. And also the reason we're using California law is you have to have jurisdiction over the company. So I used a lot of, and when we're in their civil courts, we need to use a lot of their law. And even though this pertains to international criminals, they're still bound as a company by these laws, no matter who it's being applied to. They're also bound by the laws of other countries, but we won't get into all that right now. So the defendants are arguing that I failed to identify any provision of an agreement allegedly breached. Incorrect. Are you kidding me? So I go into what I referenced with regard to their terms of service and community guidelines, that they are definitely committing selective enforcement by suppressing content of multiple creators, myself included, while that are exposing that known fugitive. And that's a key part of this case. I'll explain that in a minute. But this content is exposing this person for committing crime on their platform, just as we've told them he is, while allowing that same fugitive's harmful content to remain. That's a breach of contract under 43010E. It violates specific enforceable provisions of their own policies. Now, they're going to try to claim, and they do try to claim, in their Demurrer that none of those provisions are enforceable or have been breached because they're using the catch-all portions of their terms of service, where they may or may not have to take someone down or turn someone in, and they're not held to those kind of standards. They're a private company. They are held to those kind of standards when it comes to specific portions of those terms of service, where they talk about, upholding the law, and that they will take down, it says will, anything that is illegal, and this and that. So those are the things that are key, where we have a catch-all on them having violated those portions of those policies. So the content is not merely something I find objectionable. That's actually a lie that they're stating. It's content in violation of state and international law, terms of service, and community guidelines also, duh. And what I'm hinging on there is that they specifically state that they will not uphold, they will not allow illegal content to be on the platform. So I state here that I clearly referenced the specific provisions in their terms of service and community guidelines that form the basis of a contractual relationship. That's another thing they try. They try to claim there is no contractual relationship at one point, even though they argue how they didn't breach it, but then they try to argue that there isn't one. So they try everything. So, which is what you do, but, and the court can then suss out, do they think there's a contract? Do they think it was breached if there is one? So they try every out there is. I prove up that there is one. But anyway, it's clear YouTube and Google's selective enforcement of their terms of service and community guidelines, suppressing the content of multiple content creators, myself included, and that content is exposing the known fugitive, while they at the same time allow that fugitive's harmful content to remain, that constitutes a breach under CCP 43010E. It violates specific enforceable provisions of their own policies. So that's another thing to mention here. At one point they try to state that these provisions are not enforceable because they go to parts of their contract that are catch-alls, like, and that's what makes it an adhesion contract, where they pretty much have an out for anything as a private company is how they try to have it be interpreted by the courts. And they win a lot of times doing that. But this case is very different because of the fact that that content that we are being suppressed, the content that's being suppressed is about this criminal who is simultaneously committing crime on the platform. And, that's them violating the policy that's very specific. There are several points in their contract that gets very specific. The main one being that they say that they absolutely will take down illegal content. It doesn't say we might. It doesn't say sometimes we do and we don't. It's our discretion. It's we do. We will not uphold illegal content. So this is what I'm weaving together here to make it clear that they're violating a very specific part of their contract. There is a contract, and that they have also suppressed speech while upholding the person who the speech is about. So this is what makes it different from a lot of other cases where you'll have someone claiming that they're being suppressed. One example would be there was a content creator who was a vegan or an animal rights activist, and they filed a suit that was for breach about the community guidelines being violated by them allowing someone to be on the platform torturing animals. And we're not just talking about like footage of someone, creating meat or hunting or something, but this was like, sadistic abuse of animals. But she didn't have a claim that her content was specifically suppressed for exposing a specific person committing a specific crime. So we do have that here. It makes it a very different kind of case. That was one of the most similar cases where someone lost that I found. There have also been a lot of people that tried the state actor thing. I hadn't known that in the past. I did more heavy research this time on a couple of those things and happened to find that. But their cases were very different from this one as well. But when it comes to reporting child abuse, they are, in my opinion, sufficiently tied to government entities who do so, and they work with them to be considered potentially in the future a state actor. That wasn't such a remote thing to go for. Anywho, legal standard. So instead of just defending yourself all the time, you need to kind of push after them. Their Demurrer fails. So under CCP 43010E, a Demurrer can only be sustained if the complaint fails to allege facts sufficient to constitute a cause of action. So the court is supposed to assume that all the factual allegations are true. The plaintiff provided, that's me, videographic evidence of the violations occurring on the platform, tons of it, which that's not necessary at this stage, but it's been provided since June of 2024, since the first cybercrime complaint form. And yet they dishonestly state that the crime only occurred off the platform. And they know this, and they've known this all along. And we're talking about serious crime here involving children. We're talking about doxing. They're already paying $174 million right now for the COPA Act being violated and the doxing of children in a much less serious, severe type of case, because it was just a matter of some of their personal info being leaked, not a murderer, telling people where they live and whatnot and looking for them. Promotion of incest, pedophilia, promotion of infanticide, serial killing, calls to action against victims of revenge porn. They'd seen hard evidence of all of the above and much more. They also know Dutch media has covered the crimes. They also know what Primal Bell's husband said in the trial transcripts, which they've seen. And those are a matter of public court record, and so on and so forth. And the victim of the most serious of the crimes, Diane, has provided them with evidence that he impersonated her, that he doxed her, that he's wanted for trying to unalive her and her child, and that she lives in hiding. She provided a sworn statement for this case. They know all of this. He's also violated their rules with his sock puppet accounts. But even the sock puppet stuff and all of that, that is proof of breach because they allow him to get by with sock puppets and all the things he does. It's not the same as the criminality because the terms of service don't say they will definitely take someone down for sock puppets. It says they will take criminals down, and yet they don't. And there are laws on the books against suppression of whistleblowers. So that is generally what we're going for here. So I go into all of the different instances of suppressing content versus things that Lagzdins has done, like the April 2023 live stream about writing his baby daughter. Factual basis for breach. So the factual basis would be their terms of service promise to maintain a safe environment and prohibit content involving harassment, doxing, child endangerment, and promotion of violence. They knowingly allowed a third-party creator to violate the terms, publishing the content, and includes, but is not limited to, doxing of the contract holders and crime victims, doxing of a child, promoting child harm, decapitation, pedophilia, calls to violence against a disabled person. That would be the family member of Catherine Richard, who they know from her affidavit and from the contents of that folder that he doxed her brother, I think, has special needs, and he included him in the doxing. That's actually pretty important by way of law. Misrepresenting the nature of the dispute as a mere objection by the plaintiff, despite documented violations of both law and the terms of the contract held by content creators with the defendants. These allegations are not speculative. They're grounded in the contractual obligations outlined in the terms, and the defendants failed to uphold them. Inequity of contract, that's a very important concept here. Like I said, other people have used it before, but differently. They weren't battling someone who's breaking the law on a platform, and that the content that they're creating that's being treated unfairly is in direct opposition to those criminals. They weren't whistleblowing on these specific criminals that they have a problem with and having that content suppressed. So the plaintiff further alleges inequity of contract as enforcement of the guidelines was applied discriminatorily and in bad faith. This supports a claim for breach under the implied covenant of good faith and fair dealing. And I had brought this up in the other petition, but not under the framework of breach. So suppression and selective enforcement, I get into all of that here, how they're violating specific enforceable provisions of their own policies. I specifically bring up other content creators like Acid for My Valentine. His entire channel was removed. That was a channel showing portions of Lagzdins' content and making commentary related to the criminality under the fair use guidelines and parody guidelines that are allowed. But he had to start all over when his content was taken down. But Mr. Lagzdins never has had to do that. And he was the one with the original content being showcased, making whistleblowers give up by having their own content removed, given age warnings like I have had, and whole channels taken down, upholding false complaints, censoring dozens of videos in entire countries as a way of stopping people from capturing the algorithm and growing an audience when their channel has 1,000 or more subs, like Acid for My Valentine did at that time, and is removed with no warning or recourse. And the same is not occurring for the channel the whistleblowing is exposing, a channel belonging to a fugitive, stating he is abusing a child as we speak. His new 1 to 2 year old bike, if you know what I mean, as stated by Lagzdins on the Goatis channel. And so on and so forth, and how he's hidden some of that content since this case has not been struck down yet. He's gotten more and more worried. He even took his Is Incest Natural video off of Rumble. So then I go into more about stating facts sufficient enough to constitute a cause of action. So we get into a little bit more about that one issue, which is that I state facts sufficient enough to constitute a cause of action. I have to prove up the existence of a contract, the performance or excuse for non-performance, how they breached, and the resulting damages. And I alleged all four. The existence of a contract. Their terms of service and community guidelines are binding agreements between the platform and the user, but specifically in the case of content creators, I get into that later, because, content creators are always checking more than just an agreement that's a generalized agreement, but every time you upload content, you're agreeing to certain things. Breach. YouTube, Google violated provisions promising to maintain a safe environment and enforce rules against harassment, child endangerment, and incitement to violence. Selective enforcement. I go again into how they suppress and remove content exposing a fugitive after proving that content was not defamatory, while knowingly allowing a fugitive's content to remain, despite multiple documented violations spanning years. Damages. Well, we have suffered emotional distress and suppression of our speech. Even just suppression of that speech can be put under the category of damages. Specific provisions violated. What did they violate? Well, their community guidelines include enforceable promises. They have a harassment and cyberbullying policy, which prohibits doxing, threats, and targeted harassment. They have a child safety policy prohibiting content endangering minors or promoting child abuse. A violent or dangerous content policy prohibits incitement to violence or glorification even of criminal behavior. Hate speech, misinformation, content that promotes harm or spreads dangerous falsehoods. So we've been suppressed and had our content censored or removed for not violating these policies, but for exposing the violations by another creator. Yet that creator, including that content, they haven't acted on it. So failure to act is proven up. Constitutes bad faith enforcement and breach of the implied covenant. So the Demurrer failed to prove these violations did not occur because they can't. If these allegations were false, they'd speak to that, but they don't address it at all. They're dishonestly stating the violations are a matter of taste, as if it was something the plaintiff just finds personally objectionable. And they're attempting to state that Section 230 acts as a shield for anything a third-party content creator does, but it doesn't. That's why they don't want to address what is in the objectionable content that's actually on the radical end of the illegality spectrum, let alone violating the contract. And it's a weak failure of a Demurrer. Supporting case law. I have two good cases here showing that bad faith in enforcing a contract can constitute a breach, even if it would technically be allowed under the contract. So that's a very good piece of case law there. And this other one shows that whether moderation decisions violate contractual promises, and they said in that case that it does. Platforms' terms of service are enforceable contracts when users rely on them, especially when you're creating content. In Section 230, we're getting into their second argument against me, which is, of course, that everything in the world is, barred by Section 230 and you can't bring an action. But that's not correct. Section 230 does not shield them from liability, as their conduct falls squarely within the statutory exceptions and exceeds the scope of protected activity. Specifically, that they engaged in reckless and affirmative acts that facilitated criminal conduct against a child, including doxing, raising funds while evading arrest for the 2-time attempted murder of that child, and I'm referring there to Diane's son, and rape of a child, which Lagzdins promotes and cites that he engages in, stating it on the platform, April 2023 live stream. Under 47 U.S. Code, Section 230E1, by the way, Lagzdins took that live stream down. Why did he do that? He only did that after the hearing where I made it clear that that was an exhibit. It was up for all that time before that. Think about that. Why would he hide it if it wasn't what he was doing? Under 47 U.S. Code, Section 230E1, immunity does not apply to violations of federal criminal law, and courts have consistently held that platforms or individuals who knowingly assist, support, or facilitate child exploitation or trafficking are not entitled to Section 230 protection. And he was talking about child and human trafficking also in that live stream clip. And YouTube makes money off of his live streams, including that one, which is another issue altogether. Moreover, the defendant's conduct was not passive or incidental to that third-party content. Rather, it constitutes affirmative facilitation of illegal activity, and courts have recognized that that's outside of the bounds of 230 immunity. And there's a case from 2016, Doe versus Internet Brands, Inc. The defendants can't invoke Section 230 as a defense to claims arising from reckless disregard for child safety and their role in enabling criminal acts. So now we get into the third thing that they do, which they do this with anyone who sues them. When they see that you may have standing or a cause of action proven up on certain issues, they'll try to then use the route of saying, well, you didn't meet all the elements, it's ambiguous or unintelligible. So for this one, they tried to say that the negligence claim, the Bain Act claim, and the intentional infliction of emotional distress claims aren't met up with all the elements. So I'm proving that that's bullshit. So the complaint is not ambiguous or unintelligible, and negligence, the Bain Act, and IIED are clearly stated causes of action. And let's prove that up. And that's the Cali Code of Civil Procedure 43010F. So supporting case law. I have a case here that shows that demurrers for uncertainty are disfavored and will be sustained only where the complaint is so unintelligible that the defendant can't reasonably respond. They certainly can respond to the allegations that I've made, but not with anything that makes them look very good, huh? Williams versus Beechnut Nutrition Corp. 1986, a demurrer for uncertainty won't lie where the facts alleged are intelligible and provide adequate notice of the issues to be litigated. Boy, did they ever have adequate notice from everybody in the kitchen sink, by the way, not just myself. And not very many cases like this have had, the victim of the criminal give you a signed statement and evidence of the things being alleged. Negligence. The elements of negligence are duty of care, breach, causation, and damages. And without boring you too much, I go very heavily into all the ways that they had a duty of care, breached it. Causation is proven up about foreseeable harm. They certainly have that now. And damages. Causation. How did their breach cause foreseeable harm? Well, back in June of 2024, when I first was showing this to them, they could have acted, but instead they didn't. So I did this case. Then I've been directly threatened over the case. I've had to seal my address. They should have been taking action way back there. And really, if Diane ever gets into it, when he doxed her and her child and committed all those crimes and all the stuff that went on with Catherine, people were drawing their attention to that and they did not act. And this is not just a matter of taste, it's a matter of crime on the platform. So you want to get into foreseeable harm. And now they know about all of that and still won't do anything. Imagine if anything else happens. The foreseeable harm element, talk about meeting that up. But even right now, having to go through this and move forward while he hides in plain sight, they are acting in a manner that they are causing continued foreseeable harm. People having to continue to work on this, spend time on it, and be put at risk doing it just because they won't act according to the contract and according to the law. That is enough for causation. Damages, enduring threats, likely from Goatis in many instances, and the history of sock puppet creation and activity has been proven up. And not just myself, several content creators have been directly threatened. Having to scrub our social media, certain things we can't do because if we want to continue this effort and be safe, we have to, take these precautions now, all because they didn't want to act. Speaking out to stop crime is a right, not a privilege. And although the platform is private, it's open to the public to abide by all applicable laws and its own contract. So the Bain Act is particularly useful when you're talking about whistleblowing. We do have a protected right to try to stop crime and to speak out against our government and things of that nature. And this is usually used in that capacity. So to establish a claim, and it's part of the Civil Code, Section 52.1, there are certain things you have to prove up. You have to prove up that you had a right that is a granted right by the Constitution, that it was interfered with by threats, intimidation, or coercion. So the essential elements, I was exercising a right a constitutional right. The defendant interfered with it, and that interference is intentional. And you have to add the added pressure of either threats, intimidation, or coercion. I'm going with intimidation because there weren't exactly threats, not from the company itself, and there wasn't coercion, but was there intimidation? Absolutely. And I'll show you the standard for proving that up. So my right was secured by all of the above. It can be a U.S. or a California constitution, state constitution law also. In my case, it's all of the above. The defendants intentionally interfered with it. They attempted to intimidate all whistleblowers. The fact that they did it to all of us, and that they did it with such an ungodly amount of evidence being put in their face will help prove this up. They wanted to keep us from exposing the on and off platform crimes of wanted fugitives Goatis, Lagzdins, and Rina Abdullah. There is causation because the plaintiff clearly sees the platform will retaliate punitively against the acts of whistleblowers exposing Lagzdins in a way that is disproportionate to the behavior towards the criminal content. The harm incurred is a violation of the aforementioned civil liberties, a breach of the contract, and the emotional distress via this long, unnecessary process when they have the facts needed to compel them to act according to the contract and to the law. So the remedies available include injunctive relief. That's what we're asking for. And by injunctive relief, it means I'm not asking for money. I'm asking for them to do an act. And that act would be the one according to the contract that they're supposed to do, which is to take down criminals who post criminal content and stop letting them earn money, letting them have access to minors, and making money off of them. Take them off and turn them into law enforcement also. The case law that shows that when it comes to terrorism against a child, they are supposed to do that is what I cited in the other petition, and I'm also asking for that relief here. And I'm using the fact that in their contract they state they'll abide by all state and federal law, and that's what the law says they are to do. IIED, intentional infliction of emotional distress. So the key elements of that are extreme and outrageous conduct, intent or recklessness, causation, and emotional distress. So I didn't harp on that too much because I'm not the main victim of crime here, but you better believe looking at this and doing this long is disturbing to someone. It does put you somewhat at risk. And are they doing it with intent or recklessness? Both. It's reckless to allow this to go on, but at this point, they definitely know what they're doing. So that gives you some intentionality here. Once you know better, you can do better. But if you don't, it's intentional. So the defendant's behavior goes beyond the bounds of decency, and I prove it up. I prove up all the ways they know, everything there is to know, including Goatis Lagzdins himself talking to PZC about the crimes. They have every kind of evidence they need that this is all real and that they are aiding and abetting this activity. The defendants know that this would be distressing to the plaintiff, and I bring up how in our second meeting, I did burst into tears because I was shocked that they will push this hard against protecting two very small children. So there's no question these elements are met up. Do they have a contract with me? They spend a lot of their time talking about not breaching it, then they try to say that there isn't one. So let's show how there is a contract. Relevant case law. First of all, let's make it clear there's different kinds of agreements. So the click wrap agreements are the most enforceable forms of digital contracts, whereas the browse wrap are unenforceable. They differ. Some of the sign wrap agreements are and some are not. In this case, it's a click wrap agreement between a content creator and the platform. So that's another thing that makes this case different than if I were just filing it as a member of the public and not tying it into being a content creator. Relevant case law. This one, I don't know how to say that name. Tija versus Facebook. The court upheld the contract, noting that the sign-up process provided notice and acceptance. So if you join a platform like YouTube or TikTok by agreeing to the terms during the account creation, that is enough. And that's not even a content creator necessarily. Keybaugh versus Warner Brothers. The terms were clearly presented and accepted. This highlights how platforms must present terms clearly to the creators and users alike. Their verbiage regarding rejecting criminal content, not allowing it on their platform, it's clearly presented with no gray area up for interpretation. And those terms are accepted by content creators who sign it and abide by it, including me. For content creators, the court traditionally evaluates when they click I agree or take similar affirmative action, whether the terms were reasonably visible and accessible, and if the platform didn't materially change them without notice. In this case, I clicked I agree. I continuously agreed each time I make content, and the terms are accessible, visible, not ambiguous, and they're not materially changed. They're binding on both parties, and the defendants breach it when they hide truthful videos in the Netherlands and allow fugitives to post criminal content on the platform and leave their channels active after they've violated multiple terms and guidelines as well as the law. The selective enforcement enacted against me and other whistleblowers is a suppressive act and violates the Bain Act. Then I go into their case law, sucking, basically. And it really does. It relied on authorities that are inapplicable to this case, and some of them have actually even gone further in litigation, and the ruling has changed. So that was a cool finding, and I'll show you that. So I go into how Blank versus Kirwan, that ruling shows us that Demurrers test the legal sufficiency of a pleading, assuming all the facts are true. So the case law used to support a Demurrer has to align really, really closely with the facts alleged in your case. And their case law does not. The courts routinely reject case law that's factually distinguishable, where the precedent involved is materially different than the facts in the case that is before them. And it is so in this case. So here's an example. And of course, I go into that it is too dissimilar. And they also highlight partial outcomes, ignoring what's occurred post that initial ruling. And also, they use a lot of really old law. So Barnes versus Yahoo is an example from 2009. Yahoo was immune from a lawsuit for failing to remove fraudulent profiles of this lady. And the court held that they could be sued, though, under promissory estoppel because they made a specific promise to remove the content and then didn't do so. So let's go into right here. They rely on this old judgment in a case where the party bringing suit isn't a content creator. They're not bound to certain terms and conditions in a contract with YouTube and Google. They're a member of the public complaining about crime against her, and not related to content she created, but rather content someone else uploaded related to her. So even with this being the case, the court still allowed them to go forward on promissory estoppel. Precedent relied upon involved circumstances not analogous to those presented in this matter. It's inapplicable. In this case, if the plaintiff is a contract holder, me, contract holder, being suppressed and intimidated out of calling attention to these fugitives, one who's running scams and two who are evading arrest. Okay. So this case, Barrett versus Rosenthal from 2006, they held that Rosenthal was immune from liability under Section 230 because Congress intended 230 to promote free speech, and it shields users and people who post third-party content creators' content from liability. So they extended, that immunity to individual users is what this case was about, not just the service providers. So reposting defamatory content won't create liability. So if you post something someone else created and it's defamatory, you may not be liable is the idea there. But this case isn't about YouTube posting defamatory third-party content. It's about content suppression, a breach in violation of the law and contract law, and such serious crime as child rape, promotion, calls to commit murder, doxing a child, so on and so forth. They also, ironically, using this case about defamation, they upheld false defamation complaints against other creators, but won't take anything down for Diane that's defamatory. So it's very clear selective enforcement. PragerU versus Google from 2022. And this was about advertising restrictions being placed on certain videos to prevent the user who posted the video from getting the revenue. PragerU alleged that they were being discriminated against because of their politics, basically. And they lost that case. The court rejected the arguments that the defendants are themselves information content providers and that their terms of service are subjecting them to liability, notwithstanding the act. And the act immunizes the defendants from PragerU's state law claims. So how is that distinguishable from my case? The PragerU case involves content moderation of lawful speech, and they lost that case. So what's the difference here in that case and this case? And by the way, they lost that case because of Section 230. They won based on immunity. So PragerU, though, is distinguishable because it involves content moderation of lawful speech. We're talking about unlawful speech, not lawful speech. This case involves a platform knowingly hosting and promoting illegal criminal content that falls outside of the protections recognized in PragerU. And I went into a lot more detail there, but you get the point. Jane Doe versus Uber. This was interesting because this involves rape, so it's very strange. But of course, it also involves like vicarious liability of an employer, and they're trying to make a connection between being, the third-party content creator is essentially not someone they're responsible for. So let's look at this though. The case was actually post the initial ruling. They don't go into what happened since, which is interesting. So Jane Doe versus Uber, 3 women sue Uber after they are sexually assaulted by individuals pretending to be Uber drivers, basically. And they had Uber decals, and they were abducted and attacked. I put, what's interesting is what is not highlighted in the defendant's use of this case. The Ninth Circuit concluded that the Jane Doe opinion had since been called into question by an even more recent decision from the Cali Supreme Court. We have Doe versus Uber, and then we have Kusiemba versus Victory Woodworks, Inc. No other court has followed the holding in Jane Doe number 1. So in 2024, here we see that the Ninth Circuit Court issued an unsigned opinion where it reversed the district court's summary judgment after concluding there is convincing evidence that the Cali Supreme Court would not follow Jane Doe number 1. Instead, they concluded the risk that an Uber rider may be kidnapped or assaulted by a predator posing as an Uber driver would not have existed without Uber's own conduct. It noted that the plaintiff provided evidence of 4 categories of their affirmative conduct that increased her risk of harm. And this really ties into our case here. Marketing Uber as safe, failing to implement adequate safety features, negligent driver screening and monitoring, and designing the app in ways that facilitated assaults. So similarly, YouTube is enabling young people to find Goatis Lagzdins' channel and consult with him for $200 an hour to make an introduce yourself video for him where they bow and say, I pledge allegiance to Lord Goatis, so they can join his Telegram, which is advertised on YouTube. And there's a special pro-incest space there where they can go further in breaking the law. They enable him to earn money on videos as he evades arrest for trying to unalive a toddler. He evades arrest while on the run from law enforcement with a baby girl in tow, which he stated plainly on the site that he is abusing sexually. They enable this knowingly while marketing YouTube as a site they opt to keep safe and compliant with local and international law, a site they particularly want to keep safe for children, they claim. They cited an earlier case and not the case law that makes that ruling irrelevant and points to exactly why this case needs to be brought to trial. Then they do also Gentry versus eBay. So that's another attempt to hide behind Section 230. It's dissimilar. The plaintiffs purchased autographed sports memorabilia on eBay and allege that they violate California's autographed sports memorabilia statute by failing to provide certificates of authenticity. Talk about reaching and even using this case. They claim eBay was negligent and engaged in unfair business practices. This crime does not fall under the scope of what would take Section 230 protections away as we have it in this case. It doesn't involve retaliatory enforcement of rules towards one party to hide crimes of another. Retaliatory enforcement where a platform allegedly punishes or suppresses a user's content in response to protected activity such as political speech, whistleblowing, or criticism. While the platform itself may not have been involved in the business practices in the eBay case that gave rise to the claim, they are not accused of suppressing or retaliating against Gentry. There were no allegations of retaliatory conduct by eBay, so no violation of laws related to serious crime against children or anything like that exist in that case. Fosta Sesta created an exception for sex trafficking, allowing civil and criminal liability for platforms knowingly facilitating such content, and I go into how he did so. So they used the case of Brown versus USA Taekwondo as well from 2021. And that's where some former athletes trained in Taekwondo filed suit against their former coach and several others, stating that the USA Taekwondo entity failed to protect them and were negligent. The defendants state that plaintiffs had not adequately alleged they had an affirmative duty to take action to protect the plaintiff from the abuser's abuse. The trial court sustained the Demurrers and entered judgments of dismissal. But guess what? The Court of Appeals reversed that on one of the actions, one of the entities, USAT. So this was not a case won against both parties, I bring up. And then also the difference is that the plaintiff adequately alleges the affirmative duty of the defendants to take action. There's an allegation of retaliatory enforcement completely dissimilar to this case. As with all case law, there's the matter in this case of knowingly violating law in a reckless manner, not merely negligent at this point and knowingly breaching the contract while suppressing and intimidating those who ask them to act in accordance to both the contract and the law. So this isn't like some Taekwondo entity not knowing that someone is abusing children, but they should have. This is someone with extreme, disregard for all the facts being put in their face, going ahead and intentionally acting in the manner that they are. So conclusion. I established all the elements for proving negligence, violating the Bain Act, intentionally inflicting emotional distress, that they are not, they have met the exceptions to the Section 230 immunity. They apply to their actions in this case, and that there's no ambiguity whatsoever. So I'm asking that they provide the relief of taking them off of the platform and turning them into law enforcement so they can be apprehended. Such relief is necessary to prevent ongoing harm, ensure compliance with applicable law, uphold the integrity of the judicial process, and so on and so forth. I respectfully request that they overrule the Demurrer and grant the injuncted relief or proceed with litigation, meaning they can either just do those two things I'm asking for immediately or let us litigate why they should or should not. So that's the end of that one. So the other thing they filed was a request for judicial notice related to their terms of service and community guidelines. So one of the reasons that I will object will be, firstly, that she didn't tell me this until the day they filed it. It was like right before, the afternoon before, and then the next day they just filed it, even before I answered her. So I answered her and said that I did not object to the filing, but I do object, of course, to the reasoning within the filing. But pointing out that they did this in such an untimely and unfair manner, one of the reasons I didn't bother objecting to the filing is that it would mean more hearings. It would mean we would have hearings on whether or not they could file the document. And I don't, they would probably be allowed to file it. So there's no point. I didn't see the point in battling that. But pointing out the untimeliness proves up certain behavior on the part of the company, because we had a meeting period that was a month or more before this, that she could have mentioned that. We had a stipulated agreement on when we would file things. And even within that entire period, that wasn't mentioned. And we had a hearing in between that, it could have been mentioned. So it was never mentioned. So that is, sneaky, nasty behavior. And then I also object to it also for other reasons. So let me show you. So procedurally, that's what I just first explained, that when they were doing it and whatnot. Substantive objection, breach of contract and public policy violations. So YouTube is asserting that their terms of service and community guidelines preclude breach claims, at all, basically. This assertion is flawed for the following reasons. Number one, it's an adhesion contract. And by that, I mean it's drafted in their favor, non-negotiable, and it's imposed on users without really the ability to negotiate any of the terms. You either agree or you don't get to use the platform. So under Cali Civil Code, Section 1670.5, courts may refuse to enforce unconscionable provisions in those kinds of contracts. Their invocation of immunity contradicts its own equity-based language and policies, which promise enforcement against harmful and illegal content. So that wording will work against them on this. So hosting criminal content and profiting from illegality, their community guidelines explicitly prohibit that. And then I give the exact quote: content that endangers children, promotes violence, or violates local laws is not allowed on YouTube. Despite this, they knowingly host a creator who promoted harm against a child repeatedly, among other crimes committed on the platform like doxing, revenge porn, calls to violence, with entire families' addresses posted, social security numbers, ID cards, and he runs scams. They're wanted fugitives evading arrest. They continue to profit from and promote them. People that violated the contract, and they violate the contract by doing so, and they violate the law. It's a breach of their own stated policies, and it violates the Penal Code, Section 272, contributing to the delinquency of a minor, and potentially 18 U.S. Code 2258A, federal reporting obligations for child exploitation, which I heavily cited in my other petition. Suppression for whistleblowers. YouTube's actions in suppressing whistleblowers who attempt to report the criminal conduct violates public policy and undermines its contractual commitment to safety and transparency. So the courts have held that contracts can't be enforced in ways that violate public policy or facilitate illegal conduct. The case law supporting their contractual liability. Lewis versus YouTube. The court acknowledged that YouTube's terms of service are relevant to breach claims, and they ultimately dismissed the case on other grounds, but not on that ground. So they use Lewis versus YouTube in their Demurrer, by the way. But what I'm using here is to prove up that even though they lost the case, they were allowed to litigate, or they would have been allowed to litigate on a breach claim. They lost on some other claims. So they already agreed that there was a binding contract that may or may not have been violated, and that they could litigate on those terms. Anderson versus TikTok. They were denied Section 230 immunity. TikTok allegedly promotes harmful content in that instance that led to a child's death, so it opens the door to platform liability. Whistleblower suppression. Moody versus Net Choice. That addressed whether laws requiring social media platforms to host certain speech violates the First Amendment. So although not about whistleblowers, it touches on platform editorial control and their obligation to be transparent. It shows courts are grappling with how much discretion platforms have in moderating or suppressing the content, including potentially whistleblower disclosures. And I go more into the Anderson v. TikTok because it suggests platforms may be liable when they knowingly facilitate harm, and it opens the door to whistleblower claims if they suppress internal reports or public warnings about such content. So there has been some social media addiction litigation, which the only way that ties in here is that it's just like a coordinated effort to litigate against these platforms, but it's based on what's in their contract. And there are several of them, and they vary by state, the different lawsuits, but People versus the State of California versus Meta is one that I rely on because it's California law. And this one here also talks about violation of consumer protection laws. Now, these cases are ongoing, but why they're important for the objection to the request for judicial notice is that they show that the plaintiffs are alleging that the platforms are ignoring warnings about certain things where child harm is in play. So they're exploiting vulnerable minors and suppressing those who draw attention to those facts. And that's a key part of this case right here from 2022 in regard to social media, adolescent addiction, personal injury products liability litigation, MDL number 3047. That's like a class action litigation. And each of these cases hinges on platforms failing to uphold their own contractual promises, especially found in the terms of service and community guidelines. And the defendants are part of that litigation as well. They're actually one of the parties being sued there for their contract being breached, and that's in litigation. So basically, I proved up that their terms of service and community guidelines don't on their face bar litigation for breach claims. That's what this document is aiming to do that they filed, and that's what I'm arguing against it. So, and I'm asking for the same relief that I ever did, which is to take them down and turn them in. So that's the gist of those two documents, and I like that a lot of you are really into knowing about all the legal reasoning and all that good stuff. And for those of you who aren't that into that, hopefully what I said made sense. And but at least we're all on the same page of understanding that obviously we don't want to live in a world where corporations don't care about the most vulnerable among us being harmed, especially when they know all about it and could take action and should, and say that they will. So that's what this is about. And I'll make some content next week of some kind, and I'll do that regularly in some form or fashion between now and the time of the hearing. As always, please keep sharing the story, share Diane's Patreon channel and GoFundMe. Tell the story, share Rotten Mango's videos, share my videos, anything you can do to keep the awareness going. Counter Lagzdins' dishonesty whenever and however you can, and we will get somewhere with this. And also, I think the next piece of content I'll do, I want to give a shout out to Cloak and the Dagger for some stuff he sent me that's very interesting that I might even use in future if and when we do litigate. I didn't get a chance to really review it properly because I had to do this, and the content really needs to be just kind of about this right now, just to kind of get this laid out. And then it'll be really fun to explore. It ties into what he sent me, ties into this topic, but it'd be interesting to do like a little video review of that. So we will look at that maybe next week. He sent me a couple things actually. So shout out to him and to everybody doing this important work. You're awesome, and I love you, and I hope you have a wonderful week ahead, and I'll see you soon. Bye-bye.